Major breaking news, another huge win for Donald Trump's administration and the DOGE team set up by Elon Musk over the deep state. Major victory in the United States Court of Appeals for the Fourth Circuit, shutting down an attempt to thwart the efforts of DOGE to cut back on the size of our federal government. Let's break it down. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have a huge victory for Donald Trump against the deep state yet again today in a big decision by the United States Court of Appeals for the Fourth Circuit right there in Virginia and Maryland, right there around the Beltway, touching fingers with the deep state. We have a decision by the Fourth Circuit that says that Donald Trump's efforts, alongside the Department of Treasury's head, Scott Bessent, and Elon Musk's DOGE team, which of course is designed to go into these federal agencies and try to figure out what's going wrong with them and make them more efficient and cut staff wherever possible, cut costs wherever possible. It turns out there was an attack on this DOGE effort by a group of teachers, the American Federation of Teachers, among others, claiming that federal employees had some sort of privacy rights associated with their data that could be found in the computer systems and the databases of the federal government. Those same databases and those same information clouds, or whatever you want to call them, that the DOGE team wanted to go in and take a look at to try to figure out what's going on, if there's any shenanigans occurring, if there's any inefficiencies that could be cleaned up, and so on and so on. Donald Trump ordered the DOGE team to do this with all the federal agencies, and it turns out that a group of employees really brought a lawsuit saying, no, it's ridiculous to think that the President of the United States can use other employees of the federal government, i.e. the DOGE team, to look at all this information associated with the employees of the federal government who work for the President of the United States. It's ridiculous to think that the president and his DOGE team can look at this data associated with the employees working at these agencies to try to make recommendations to improve them and or fire them. This is a violation of, among other things, the privacy rights of these employees if the DOGE team gets to look at this information. Well, guess what? I'm happy to report that the U.S. Court of Appeals for the Fourth Circuit just shut down a lower court's decision that actually had ruled against the DOGE team, had actually ruled against Donald Trump, another rogue district court judge. But I'm happy to report in a 2-1 decision, the Fourth Circuit just said that Donald Trump and the DOGE team can get access to all of this IT, information technology, all these databases, as part of running the executive branch. And remember how I've explained to you brick by brick by brick, you use legal precedents as a brick to build other legal precedents. And that is exactly what happened here. Because a big part of this opinion by the Fourth Circuit in favor of DOGE and Donald Trump and Scott Bessent was that the United States Supreme Court, in a prior case, dealing with a very similar attack on DOGE and DOGE affiliated with employees, dealing with the Social Security Administration, the Supreme Court stepped up and said that the DOGE affiliated employees could indeed have access to the Social Security Administration's databases. So by extension, the Fourth Circuit today just said, based on that appeal, based on that precedent by the United States Supreme Court, it's pretty clear when we apply the concepts and the precedents of the Supreme Court decision dealing with the Social Security Administration, which we've covered on this channel, and we apply to the teachers and to the Department of Education and to the Office of Personnel Management and the like, guess what? The DOGE team and President Trump gets to look at all the data associated with these employees that actually are working for Donald Trump. Shocker, right? How shocking is that? That the actual employer, the CEO of the executive branch of the United States, that would be the President of the United States, Donald Trump, is allowed to actually review with his team of other government employees the data they need to look at to assess whether or not the government is running efficiently. And that might include, yes, indeed, salary and other information of people that work for the federal government and so on. And that is exactly what the Fourth Circuit said. Of course, they can get access to this data. And the fact that the lower district court judge said no, they could not is really just absurd. So in this ruling, what happened was the Fourth Circuit said there is no way that the lower court could issue a preliminary injunction in favor of the plaintiffs against Scott Bessent, Donald Trump, and the DOGE team. There's just too many hurdles that the plaintiffs suing DOGE and the federal government and the executive branch, there's too many hurdles for them to jump over to possibly win at this stage. They may ultimately win the case, the court said today. And because to demonstrate the likelihood of success, there was a whole host of barriers that the plaintiffs had to get around, one of which was standing. And here, the court said it's not even clear that federal government employees have standing to protect their data from other federal government employees that are charged by the president to figure out what's wrong with the government. So the court here wasn't even sure there was standing to bring this lawsuit in the first place. And then there was a whole host of other issues that this court explained was unlikely that the plaintiffs were going to prevail on, including whether or not the Privacy Act, which is what they relied on, the Federal Privacy Act, even applied here, because there's exceptions, again, that says that to the extent the federal government, in order to operate, needs to get access to information, they get access to the information. That's not subject to the Privacy Act, which makes a lot of sense. I mean, again, how can the President of the United States run the executive branch if he and his team of advisors cannot get access to all the information they need to assess what's going on with the executive branch? And that's exactly what happened here. And just by way of background, here is what Donald Trump did with the DOGE team in setting this up and why they needed the data. Here's what the court had to say about that. On January 20th, 2025, President Donald Trump issued an executive order with the purpose of modernizing federal technology and software to maximize governmental efficiency and productivity in executive agencies. To achieve this goal, the order takes a two-pronged approach. Outside of all existing executive agencies, it establishes a Department of Government Efficiency. That's called DOGE. Inside, that would be inside of each existing executive agency, it requires administrative agencies to establish within their respective agencies a DOGE team of at least 4 employees. The DOGE agency on the outside is then instructed to work with the DOGE-affiliated employees on the inside of the agencies to promote interoperability between agency networks and systems, ensure data integrity, and facilitate responsible data collection and synchronization. Pursuant this latter internal command, the Department of Education, the Office of Personnel Management, and the Department of Treasury each quickly created DOGE team staff with their own employees. Each agency also created a plan to give DOGE team high-level IT access to its systems. At the Department of Education, Chief Information Officer Thomas Flagg issued a memorandum that authorized the DOGE team to have full and prompt access to all unclassified IT systems and data. At OPM, Acting Director Charles Ezell requested that the chosen DOGE affiliates be added to OPM systems as admins. And at the Department of Treasury, the Treasury Administrative Services set out an engagement plan that appears to have included a grant of access of Treasury systems to the Treasury DOGE affiliates. So that seems to make a lot of sense, right? You've got sort of consultants from the DOGE team, which is working for the federal government, are working with internal DOGE people at each of these agencies to work together to kind of get the data and assess the data. But this lawsuit was brought by the American Federation of Teachers and others against Scott Bessent and others, Linda McMahon, the head of the Department of Education, and so on, the Office of Personnel Management, to try to thwart this effort. But the Fourth Circuit said no can do. There's no basis for the lower court's preliminary injunction against Donald Trump, and therefore the preliminary injunction entered by the lower court is hereby stayed and shut down. No can do, which means that these DOGE employees, both inside and outside of these agencies, can go forth and get the information to assess what wastefulness, if any, is occurring at these agencies and make recommendations to President Trump and others about how to fix all of this. And hopefully that occurs. Now, in ruling in favor of President Trump and the DOGE team, the Fourth Circuit made a particular point of emphasizing that this case is very, very similar to an earlier Supreme Court decision that said that the DOGE team can get access to Social Security information. And again, as I've explained, brick by brick by brick, you build the wall in favor of your theory, whatever it must be. And here, It's about allowing the DOGE team to get into the deep state, try to figure out what the deep state is doing so we can address it. It's like you diagnose the medical condition so you can then treat it. And that's what these DOGE teams are doing. And this is what the court had to say about drawing that analogy to the big win for the Trump administration a few months ago in the Supreme Court, and why that is binding on the Fourth Circuit and tells them to rule for DOGE today. As this appeal was pending, the United States Supreme Court stayed the preliminary injunction in a related case involving nearly identical Privacy Act and APA claims brought against the Social Security Administration and its DOGE-affiliated employees. The United States Supreme Court stay permits the Social Security Administration to afford members of the Social Security Administration's DOGE team access to the agency records in question in order for those members to do their work. This case here, according to the Fourth Circuit, and that one are exceedingly similar. The Fourth Circuit goes on to say, so while the Supreme Court's stay of a preliminary injunction against the Social Security Administration is not conclusive as to the merits of this preliminary injunction against education, OPM, and Treasury, it nonetheless informs how a court should exercise its equitable discretion here. Mindful of the Supreme Court's actions, we now resolve the government's appeal in favor of President Trump and the DOGE team. So to wrap it up, huge win against for Donald Trump and the administration, including the DOGE team, as continues to burrow in and try to figure out what's going on with the deep state in Washington and these federal government employees, which in my opinion, frankly, the more we fire them, the more we get rid of them, the better we will all be. That's my view. Tell me if you disagree in the comments below. But again, another big win for the DOGE team, for Elon Musk, for Donald Trump, Scott Bessent, and the whole Trump administration. So congratulations to them in this victory in the United States Court of Appeals for the Fourth Circuit that just spanked another rogue district court that was trying to shut down the Trump agenda with their games. And that, again, did not work, largely in part because the U.S. Supreme Court had previously ruled in a similar case that lower courts cannot get in the way of President Donald J. Trump overseeing the workings of the executive branch. Because after all, in Article 2 of the U.S. Constitution, it vests all the authority of the executive branch of the United States in a single president of the United States. And because Donald Trump is the president of the United States today, he gets to oversee the entire executive branch, just like Article 1 talks about creating the Congress and Article 3 talks about creating the Supreme Court and the courts. Article 2 is the executive branch, and that is the domain of the president of the United States, and that today is President Trump. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.